Greetings of the day, everybody, and welcome to chapter 7 of the course of CSR. Today, we are going to learn about corporate crimes. That's the topic for the day. Now, if we look into these words, corporate and the word crime. Now, the word corporate is usually associated with civil law crimes, while the word crime itself gives you an idea that it belongs to the criminal law. When we look into a crime in general, there are two main things we require. One is mens rea and one is actus rea. That is a guilty mind, and one is the action. Okay. And as a company, okay, which is made out of concrete and cement and brick, it's quite obvious it doesn't have its own mind. A company in such a case cannot be held guilty because it has no soul to be damned and no body to kick. Okay, so basically, if we look at company, how can a company, a building, a concrete building like this would be held liable for a criminal crime? Now, this took a lot of years for the jurist and for a lot of development of many years which was required for the corporate crime to be as developed as it is now. So the first development or the first instance was seen when Lord Damien said that crime such as a treason, felony or offenses can't be attached to a company. Okay, the main reason here being is a company cannot have a guilty mind. Secondly, he said that therefore mens rea, which is the guilty mind, is an important component for any criminal act. Without mens rea, okay, without a motive, it's very much like very hard to pinpoint as to why the person or why that personality has committed the crime. It's very important to have a guilty mind, and such a guilty mind cannot be attached to a company. Therefore, in most initially in the very beginning stages, the main thing they looked into was the employer and the employee. So all the employers were held accountable for the actions of their employees. So if we look into with regards to this, if we look into the development in India, we have a case called as the in the case of A.K. Gosala versus Sri Venkateshwar. It was said that in this case, what had happened was there was actus rea and there was mens rea. Okay, in this case, what had happened was there were two corporations who were charged for fraud under the IPC. Therefore, it was held in this case that company body will not be said to have necessary mens rea. Okay, because a corporate body, okay, cannot have mens rea. Okay, it cannot have a guilty mind, nor it can be sentenced to imprisonment. You cannot send a concrete building in the prison as it has no physical body. So, in such a case, the main time where this started developing was in the early 1600 and the 16th and the 17th century. Around this time, the corporation could not be held liable. But it was later on in the 1700s, the corporate criminal had faced a lot of obstacles in the when it actually started developing. Around this time, what had happened was there were four main obstacles which were there in the place or in the way of the development of the corporate crime. The first one was around this time, the 1700s, the concept of corporate personality did not exist. Okay, now, in the case of Solomon versus Solomon company, it was held in this case the actual concept of corporate personality was developed, but this case was yet to be developed in the 1700s. Okay, therefore, due to this non-existence of the company, okay, as an artificial person, it became very difficult for the courts to differentiate between this corporate personality and whether a corporation should be held liable or a company officials are supposed to be held liable. So they mostly went on with the whole concept of the vicarious liability. Okay, the second obstacle they faced was blaming the corporation was not an option. It's as simple as that because a concrete building cannot be held for a criminal offense. Okay. The third obstacle they faced was with regards to the bifurcation as to whether a company law or a corporate law was a criminal law or whether it was a civil law. Therefore, it became very difficult for the jurist itself, okay, to understand the nature of the company. It should be held liable as a criminal person, okay, as a criminal entity or as a criminal accused, okay, because if we are expecting it to be held liable as a criminal accused, where is the mens rea? Whom you are going to blame? Okay, where is the actus rea? So here these questions were raised. Another fourth one and the last one obstacle was with regards to the ultra virus doctrine, as the courts could not hold a corporation accountable for the act. Okay, in such a case, crimes that were not provided for their character, okay, as there was no character which could be attached to a corporation. But since then the times have now changed. Okay, there are a lot of theories which have been debunked, and we also went through a phase of the Solomon and the Solomon company case. So in such a situation, we have now various laws relating to corporate personalities. We also have the concept of lifting of the corporate veil to find out who is actually running the company. Okay, and also addressing the criminal nature and the corporate existence of the company. Therefore, in the early 20th century, attaching criminal liability to a corporation started flourishing. Now let's look into some features of the corporate crime. Now, first and foremost, there may not be an individual victim but a collective victim. Secondly, it's not easy to detect the corporate crime because there is no characteristics. Okay, there is no way in which to realize, okay, this is the act of the corporation. It's on the company, it's on the jurist itself and the lawyer who is against the company to make the judge understand about the nature of the corporate crime. Next, the crime is committed within the structure and within the official legal activity. So this crime should be related to the legal activity and with regards to the company, okay, and not otherwise. And lastly, there is no personal contact between the offender and the victim. So what happens with regards to this is that it is important to have or sort of like a distance, okay, between the personal contact between the offender and the victim. Now next, let's look into the types of corporate crimes. Now the first type of corporate crimes are called as the white collar crimes. Now these crimes are in relation to the elite class. Like there are various classes of employees and the employers in a company. Okay, the very elite class will include mainly the CEOs and the other officials of the company who are mainly involved in taking major decisions of the company. Okay, now this what will happen in such a case is that this elite class of the people will in a way try to manipulate the corporation. Okay, so in such a case, the mostly what is done is the corporate veil is lifted to see as to who is doing the crime. The main motto here is to identify that this elite class official use their decision making power for their personal gain. The second type of corporate crime is known as the occupational crime. Now this takes place at the lower level, okay, at the employer level, at the employee level. Okay, so this can be in form of protest against the company. It may be as low as the treasurer or the lower ranking officer, and it may also include other examples of occupational crimes are robbery, evasion of taxes, fraud, manipulation of sales, and other crimes which actually have a huge effect on the company. Now the third type of corporate crime is known as the state crime, and this is as simple as it says that it is done by the corporate setup along the side of the government. Now let's look into the theories of the corporate criminal liability. Now the first theory of the corporate criminal liability is the aggregate theory. Now according to this theory, it is to be determined who is to be held liable. Okay, now in a case where there are many officials who are involved, okay, if there are many, usually a company on its own will never run on its own unless it's a certain type of a company. Okay, so mostly a company has many officials, many employees, many employers. Okay, so in such a case, when a crime is committed, it is to be blamed not only on the one person but all the employees who helped to commit the crime. Okay, so basically the whole aggregate of everybody is taken. Okay, so not only one person is blamed. It's obvious that when a crime is committed with regards to this huge corporation, it's very impossible for a single person to do all the acts. In such a case, like it's mostly the whole aggregate is taken. Okay, so everybody is held liable for the act which is committed. But obviously, the inquiries are made as to who all were involved in committing the act. The second type of theory is the theory of vicarious liability. Okay, we have studied in the beginning of the chapter that a person may be bound to answer for the act of another. So basically, this is with regards to the master agent liability. So when an agent, that is an employer, does any act within the framework of him working in the company, okay, not outside the purview of that framework, or not outside the time limit of the working in the company, and with regards to the company, okay, then in such a case, if any crime is committed, then the employer or the master is held liable. Okay, and it should be within the course of business. Similarly, a corporation may be held liable for the act of the employee. Okay, now the third theory is the theory of identification. Now in this theory of identification, a corporate personality is held liable for the crime and other regulatory offenses. Not all will be held liable, but the people must be identified. Okay, the people who are corrupt in the company, okay, and the people who are directing the mind of the corporation, okay, to be in a certain direction for their own profits or for whatever it is, okay, should such a people or such a person should be identified. So now let's look into some of the Indian cases. Firstly, let's look into the case of Z Telefilms Limited versus Sahara India Company Corporation Limited. So in this case was with regards to defamation. Okay, and in this case, what had happened was the criminal intention could not be established on the behalf of company. Okay, so when a criminal intention itself could not be established, therefore the company was not held to be liable. Let's look into few more cases. That is a Motorola Incorporation versus Union of India. This case was with regards to the cheating allegation. and the mens rea was again not established and said to be completely non-existent. So in such a case, the company could not be prosecuted for cheating under section 420 of IPC. Lastly, let's look into few other cases. That is, in the case of Standard Chartered Bank and others versus Directorate of Enforcement. In this case, it was held that the only way a company can be punished is in the way of heavy fines. So in today's chapter, we learned about the historical development of the corporate crimes. We looked into the features of corporate crimes, we looked into different types of corporate crimes, and we also looked into few theories of corporate criminal liability. And finally, we looked into various cases as well as the effect the corporate crimes have on the society. Okay, so this is the last chapter I'm giving as a video. So next chapters will be mostly given through PDF files. So thank you very much.